Let me give you a kind of an illustration of what can be done inside of a living trust planning to kind of put it some into context. There's Bill and Mary Jones. Bill and Mary, kind of a compilation of clients that we've had come through our office over the years. And they're not rich. Bill's about 65 or so, recently retired. He got $700,000. He and Mary do. Mary never worked. She was a homemaker and raised the two kids in a split level, 2-story house that they've got. They got 2 children. Got Susan and John. Susan's college graduate, has an MBA, works at the bank. She's been doing well, married to Jason for several years. They have a child of their own. So they're very proud of Susan. And then there's John. Now, Bill and Mary love John, but John's had some issues along the way. He's had some substance problems along the way. He's had, problem with education. He never quite finished school, so he hasn't been able to hold good jobs and such. Kind of been a free floater. He's started some businesses from time to time and had those fail from time to time, and they've had to bail him out of those. So they realize that they need to do some special planning for John probably, and leaving things outright probably doesn't make the most sense to them. Bill and Mary signed wills years ago and haven't looked at them since. They, the kids were still minors. They named some uncle as an executor of the estate and is the guardian of the kids, and he's deceased now. So, but right now their wills just say everything to surviving spouse, and upon death of surviving spouse, everything goes equally to my kids. Right, very common way of distributing assets. We call them "I love you" wills. And so the Bill and Mary have the typical "I love you" will that they need to update. Well, before Bill gets around to updating his will, he has a stroke. Now, the good news is modern medical science is able to keep Bill alive. The bad news is he's in a severely disabled state. Mary's going to have to care for Bill in this 2-story split-level house that's not really appropriate for a wheelchair. Not wide enough doorways, no ramp. The bathrooms aren't big enough, toilets aren't high enough, all sorts of problems with that. Mary needs to sell the house. But she can't, because how does Bill and Mary own their house? Joint tenants, rights of survivorship. Mary can sign the deed, but Bill can't. He's incapacitated. In order to get that deed signed, we've got to go to court and get a conservatorship opened up over Bill, where the court takes charge of Bill's affairs, appoints somebody, i.e. Mary, to be in charge of those affairs, but we got to go through a process of due process to do that. We have to notify Bill, we have to notify Bill's children, we have to get affidavits or testimony from doctors to be able to do this. Ultimately, we jump through all these hoops, get in front of a court. Court eventually is going to sign this order, but it's going to take some time to do, and it's going to cost some money to do. End of the day, we're going to wind up then with a court order that declares Bill to be incapacitated, tells Mary she's in charge, and also tells Mary that she has to file annual accountings with the court. So we got now legal fees going on in perpetuity until Bill dies, telling the court how we're spending Bill's money, so the court can maybe second guess what Mary's doing. It's all there for Bill's protection, but it's seen as a real nuisance to someone like Mary. But that's kind of the only option that they really had to be able to sell that house. So they sold the house, bought a new house. 6 months later, Bill dies. And now we have the issue of assets that were still just in Bill's name, or in the conservatorship now of Bill's name. How are we going to get those to Mary? Good news is we got this will, but wills operate through the probate system. So we're going to take this will, we're going to file it with the probate court. We're going to get a court order eventually that says everything goes to Mary. It's going to take about 6 months to do. And we'll take care of any creditor claims. But at the end of the day, Mary's going to have all of the assets in her name. And I've already kind of told you what the probate process is. This complaint over probate that we hear is not the cost. They may complain to other people about our costs, I don't know, but they don't complain to us about it. But they do complain about how long it takes. Why is this taking so long? Why can't I just move on with things? People want things to be simpler when a parent dies. The legal fees and executor fees in an estate will vary from state to state and from county to county. It's a lot of judges' discretion as to what they will allow for fees. Mississippi uses what's called a reasonable compensation standard. Reasonable compensation is whatever the court says it is. And so there's a lot of discretion with the judge over what the fee is allowed to be. Generally, and there's a number of factors, by the way, the Supreme Court tells them to look at. The difficulty of issues, the amount of time that's got to be spent, the giving up of other work in order to take this work, the amount of time itself that has to be spent, the experience of the lawyer handling the case. All of those things are kind of factors to be considered. What it really boils down to is the court's going to multiply a fair rate for the lawyer times the amount of time spent to come up with the fee is typically what we see. Same thing for the executor. The executor also is entitled to a fee, and determination of that fee is really going to be reasonable compensation again, and a lot of discretion as to what that means. Some states use a percentage, and the percentage, frankly, would be better from a standpoint of certainty and ease of calculation than this uncertainty of we're going to spend this time and do all this stuff only to have someone object to the fee on the back end, and maybe the court pull it out from under us, type thing, or tell us we're worth less than we would be. And so in California, New York, and Florida, there are statutes that say if the fee is this or less, it's reasonable. And so as a result, in those states, the fees for probates are whatever that percentage is. And so you kind of have a set fee in those states. Generally speaking, a typical simple estate around here, for a simple estate, it's going to take 6 months to 9 months or so, is around $2,500 to $5,000. If there's not anything that's difficult that's kind of raised its head, if we wind up with heirship disputes, if we wind up with big creditor issues, if we've got to argue over assets, it can be much, much larger. And so, not to say that large, difficult estates don't cost in the tens of thousands of dollars. I'm involved in a state right now that's got about 5, 6 heirs, about that many lawyers involved, and a trust that has its own counsel, and legal fees on that case have probably exceeded $2 million. That was a big estate, obviously, to have that. But the cumulative value of all those people working on this file for probably what's now 6 or 7 years is hugely expensive. And so, so I'm not at all saying that $5,000 should be what a fee is. It depends on what's going to be, but that's kind of typical that we see in handling a typical or simple estate. Estates are public, by the way. So probate is public. You can go to the Chancery Court, and before you could go to the stacks of files and you actually pull the file that you're interested in and see what all is going on. Now it's all electronic. And so you can go up there. If you're a lawyer, you can actually sit at your desk and log in. I think if you're not a lawyer, you've got to go up there and look on their computers, but it's available. You can pull it up, and anything that's filed, you can see it. If you have a client that's got property in multiple states, you really need to talk to them about living trust type planning, because Mississippi estate court order is not going to be binding on property in Florida, not going to be binding on property in Arkansas, and property in Texas. And so we're going to need to go to Florida and Texas and Arkansas and open up probates there in order to get a court order in those states to define who owns that real estate. And so if you have multiple property in multiple states, you're looking at multiple probates. And so now the cost of this has grown and the time has grown exponentially. I was involved one time we get called in from time to time on ancillary probates where the main assets are in a different state, and we got an asset here in Mississippi, can you help with it? And I got called in on one time where the person owned, as an investment, owned post offices. I didn't know you could own a post office, but in these rural counties, these rural post offices are actually owned by individuals, and then the government leases the post office from those individuals. And this guy owned like 9 of them around the country, and he owned one in Decatur, Mississippi. And so we got brought in to probate this one in Decatur, Mississippi, but there are 8 other ones around the country in other states that also had the same probate going on in order to get titles, get ownership of those assets transferred. Had they had a living trust and moved ownership of that in a living trust, you wouldn't have had any of that. So if you have property in multiple states, you can avoid that delay and avoid that expense.